Hello, hello, all those beautiful faces. It's Thursday, June 29th, and this is the day that affirmative action has been ruled no longer the law of the land by the Supreme Court of the United States. Of course, it is the top story. Here on Google News. Let's go ahead and get that shared up there. See all the headlines here. Supreme Court rejects affirmative action. What the Supreme Court's ruling on affirmative action does and does not do. I have to say, I'm pretty impressed with these headlines so far, mostly on the reporting side of things. But I would say once you dig in, and certainly if you're on Twitter or some other social media platform, they're really going to be like what this Wall Street Journal article says. It's either seen as this great decision by people who are on the right, or it's seen as another blow to our democracy by those who are on the left. Because in 2023, we can't talk about anything without jamming it through the meat grinder of the culture wars and politicizing it, and without having really any evidence or facts or actual quotes grounding in the decision itself. That's certainly one theme that I noticed, particularly from the social media posts. I've not dug into the news and the analysis so far because I actually want to read the ruling for myself. I think that's an important and necessary thing to do if you're going to have an opinion. And if we are going to politicize this, because I'm not saying that making things political is fundamentally wrong, but doing so in a way that's disconnected with reality and just to push an agenda, you know. So we've got quite a bit here to read, but before we get into it, go ahead, hit that like button, subscribe to the channel if you're new here and you want to figure out a way to make sense of what's going on in the world. You're tired of the culture wars, you're tired of both sides trying to just push an agenda, kind of devoid of the facts, or even perhaps if you might think that one side is more right than the other side, there's something that is still missing. Well, we try to cut through those headlines. We're going straight to the source. And tonight, that means that we are going to be pulling up the Supreme Court ruling. And I think this is important stuff. I wish that more people would take the time to at least look it over. I mean, it's a long thing, I'm not gonna lie. These decisions, the rulings are about 30 or so pages. I believe the Sotomayor dissenting opinion is a little bit more than that, but you could at least look it over, right? Read the syllabus, read some of the major opinion, and get a feel for yourself, really, the logic and, the legal precedent on which this case is built for yourself. So let's go ahead and pull up the ruling so you can Google search real quick. SCOTUS affirmative action, it'll come right up, or supremecourt.gov in the opinion section. It's the most recent one. It's known as Students for Fair Admissions Inc., the president and fellows of Harvard College. And this case was argued last October, right? The session, that's what they do. They hear them all throughout the fall and into the winter. And then they go on and they write their decisions. And in June and July, many of those decisions come out. Like I said, we do have some text here to get through. It's not short, and we're only going to read the deciding opinion. So this is the decision of the 5 judges who said affirmative action is over, and then we're going to read the dissenting opinion. There are other individual opinions or opinions that one judge wrote and another one concurred with, and it's over 237 pages long. You can see this document, but we're not going to be reading the entire thing, but we are going to be reading most of the deciding opinion and the dissenting opinion, as well as this beginning part here, which is called the syllabus, which gives you the overview of the case, which really gives you a context in a way that none of these news articles and news reports are going to. So get a sip of water and then we'll go ahead and jump into it. So Harvard College, right? They were named in here, but it also involves University of North Carolina. And they are two of the oldest institutions of higher learning in the United States. Every year, tens of thousands of students apply to each school, many fewer are admitted. Both Harvard and UNC employ a highly selective admissions process to make their decisions. Admissions to each school can depend on a student's grades, recommendation letters, or extracurricular involvement. It can also depend on their race. The question presented is whether the admission system used by Harvard College and UNC are lawful under the Equal Protection Clause of the 14th Amendment. And so you will get some of this in the news articles talking about the Equal Protection Clause and perhaps a reference to the 14th Amendment. But you'll see throughout this whole opinion and syllabus part, they really do ground it in the Constitution and in these legal precedents. And I think that's important for particularly lay people who don't have any law degrees or aren't lawyers, don't have a legal background. I took a couple constitutional history courses, so I might know a little bit more than your average person because I already went through that experience of realizing, like, oh, the things that lawyers and constitutional lawyers in particular think about and focus on are not the things that us, regular, we the people think about. So it's really important when we're wading through the politics of it to understand this context once again. All right, let's keep going here. At Harvard, each application for admissions is initially screened by a first reader who assigns a numerical score in each of 6 categories: academic, extracurricular, athletic, school support, personal, and overall. For the overall category, a composite of the 5 other ratings, a first reader can and does consider the applicant's race. Harvard's admissions subcommittees then review all applications from a particular geographic area. These regional subcommittees make recommendations to the full admissions committee and then take an applicant's race into account. When the 40-member full admissions committee begins deliberations, it discusses the relative breakdown of applicants by race. The goal of the process, according to Harvard's director of admissions, is ensuring there is no dramatic drop off in minority admissions from the prior class. An applicant receiving a majority of the full committee's votes is tentatively accepted for admissions. At the end of this process, the racial composition of the tentative applicant pool is disclosed to the committee. The last stage of Harvard's admissions process, called the LOP, winnows the list of tentatively admitted students to arrive at the final class. Applicants that Harvard considers cutting at this stage are placed at the on the LOP list, which contains only 4 pieces of information: legacy status, recruited athlete status, financial aid eligibility, and race. So that's interesting. Is legacy status, because this isn't something that I had necessarily considered, but legacy status can be considered a certain form of affirmative action, right? in a way. It's not one to one, but there's certainly much overlap there. In the Harvard admissions process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. Right? So they're basically saying that one of the main reasons, if I'm reading this correctly, correct me if I'm wrong in the comments, uh, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. So they're getting in because of their race. That's what it sounds like, or a significant percentage of them once they get to that top list. So again, what amount had race gone into up to that point? Was it race that got to them to there, or are they already the cream of the crop and that's why they're applying to Harvard? I would have to imagine if you're applying to Harvard you've got something, right? But there certainly are there's some research showing that when you mismatch students and you give them perhaps that tip, that determinative tip, as they're saying, to go to college, that they actually don't do as well as they might have in a slightly like less prestigious college or less competitive college. Um, so again, we're not the time or place where we're going to get into this, but just some of my thoughts along the way. UNC has a similar admissions process. Every application is reviewed first by an admissions office reader who assigns a numerical rating to each of several categories. Readers are required to consider the applicant's race as a factor in their review. Readers then make a written recommendation on each assigned application, and they may provide an applicant a substantial plus depending on the applicant's race. So, again, substantial plus. That's similar to that language of being a determinative tip. So, it seems like it is taking pretty big consideration with all these other pieces in, just from their language. At this stage, most recommendations are provisionally final. A committee of experienced staff members then conducts a school group review of every initial decision made by a reader and either approves or rejects the recommendation. In those decisions, the committee may consider the applicant's race. Petitioner, students for fair. So, petitioner, this is the person who is coming to the court and saying, this is not fair. Petitioner, Students for Fair Admissions, or SFFA, is a nonprofit organization whose stated purpose is to defend human and civil rights secured by law, including the individual right to equal protection under the law. SFFA filed separate lawsuits against Harvard and UNC, arguing that their race-based admissions program violate, respectively, Title 9 of the Civil Rights Act, Title 6 of the Civil Rights Act of 1964, the Equal Protections Clause and the Equal Protection Clause of the 14th Amendment. So we had talked previously about the Equal Protection Clause, and now they're also talking about the Civil Rights Act of 1964. After separate bench trials, both admissions programs were found permissible under the Equal Protection Clause and this court's precedents. In the Harvard case, the First Circuit affirmed, and this court granted certiorari. In the UNC case, this court granted certiorari before judgment. Right? So there's two cases that have been coming up through the courts, the Harvard case in the First Circuit and the First Circuit. So this is a federal court had said affirmative action is legal. SFFA applied to the Supreme Court to take the case, and the Supreme Court took it. And then they also looked out and they saw this UNC case, and even though it hadn't fully worked its way through the court, they granted it certiorari and put the cases together. And so held, so this is the decision, Harvard and UNC's admissions program violate The Equal Protection Clause of the 14th Amendment. So, this is the decision that they violate. Using race in admissions has been found to be a violation of the 14th Amendment. And we're going to get into some of the context and some of the history here, but it should be realized that affirmative action was always created under the notion that one day it wouldn't any longer be necessary. So I think one of the questions that should be asked, if we accept that premise, even, right? Like, we could dispute the premise of affirmative action, I suppose, from civil rights. And I think that's a larger question that we should be having is the way that civil rights legislation was constructed effective? Is it the way that we want to approach these issues when we're trying to create that more perfect union, when we're trying to make sure that people are included and are seen equal under the law? Do we want to take the same approach that we took with the civil rights legislation? Or is there a better way to fulfill that vision, right? To ensure that people of all different races and creeds and colors and religious backgrounds, or what have you, are ensured that equal protection under the law, and that we truly are this equal nation that we, profess to be, that we stake our claim in as our legacy. And we'll get there, right? The decision goes into the history and really traces this imperfect history and are trying to get it right. Because SFFA complies with the standing requirements for organizational plaintiffs articulated by the court in Hunt v. Washington. So, this is basically saying because they do have standing, right? Like, they've shown that they are being harmed and that this organization can bring forth this case. That's the first thing you have to prove in order to bring something forth before the court. Um, SFFA's obligation under Article 3 are satisfied, and this court has jurisdiction to consider the merits of this claim. So, always the first thing you have to establish is standing, and yes, the court can consider this. The court rejects UNC's argument that SFFA lacks standing, right? And we see this all the time. I feel like in cases where, again, this is the disconnect between what you and I might think the court should be dealing with and a lot of the procedural things that the courts actually do deal with a lot of the time that may prevent them from getting to the actual issues we want them to. So UNC is saying that they don't even have standing. Like, we don't need to worry about the case itself. It's like, this, who is this group? They don't have standing, and the court is rejecting their argument, but we're going to hear more about why. So UNC is saying that SFFA lacks standing because it is not a genuine membership organization. An organizational plaintiff can satisfy Article 3 jurisdiction in two ways, one of which is to assert standing solely as the representative of its members. Warth v. Selden, 422 U.S. 490, 511, an approach known as representational or organizational standing. And this is a case that set legal precedent for what they're saying. To invoke it, an organization must satisfy a three-part test in Hunt. So, again, going back to the other case, there's a test to see if they satisfied this. Respondents do not suggest that SFFA fails Hunt's test for organizational standing. They argue instead that SFFA cannot invoke organizational standing at all because SFFA was not a genuine membership organization at the time it filed suit. Respondents maintain that under Hunt, a group qualifies as a genuine membership organization only if it is controlled and funded by its members. In Hunt, this court determined that a state agency with no traditional members could still qualify as a genuine membership organization in substance because the agency represented the interests of individuals and otherwise satisfies Hunt's three-part test for organizational standing. And I think that's right? We're giving leeway to the people who are bringing the claim to the courts, sort of like get their group together, get their people together to make this challenge against a very established um, in this case, universities, but other times it's other big corporations, or sometimes it's the government itself. Let's see. See 432 US at 342 Hunt's Indica of Membership Analysis, however, has no applicability here, as the courts below found SFFA is indisputably a voluntary membership organization with identifiable members who support its mission and whom SFFA represents in good faith. SFFA is thus entitled to represent the organizational standing doctrine as articulated in Hunt. All right, B. Proposed by Congress and ratified by the states in the wake of the Civil War. So now we're getting into, right, we've got the standing, the procedural issue to the side. Now we're going to go through some of the history of, okay, where did this equal protections come from? Why do we have it? What was the original intent of creating it? Proposed by Congress and ratified by the states in the wake of the Civil War, the 14th Amendment provides that no state shall deny to any person the equal protection of the laws. Proponents of the Equal Protection Clause describe its foundational principle as not permitting any distinction of law based on color or race. Any law which operates upon one man, they maintain, should operate equally upon all. According as this court's early decisions interpreting the Equal Protection Clause explained, the 14th Amendment guaranteed that the law in the states shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the states. And so again, this is text from the 14th Amendment, and the 14th Amendment was created just post Civil War. So we're talking, right, Civil War was 1860s, first half of 1860s, so this is after that. All right. Despite the early recognition of the broad sweep of the Equal Protection Clause, the court, alongside the country, quickly failed to live up to the clause's core commitments. And so this is noting the fact that just because we had the Equal Protection Clause doesn't mean that we actually followed it. In fact, we know we didn't. So there was no slavery, but for almost a century after the Civil War, state maintained segregation was in many parts of the nation a regrettable norm, right? So this is Jim Crow laws, this is, separate bathrooms, separate water fountains, and, Black people not being able to go into restaurants or other public accommodations. The court played its own role in ignoring history, allowing Plessy v. Ferguson, the separate but equal regime that would come to deface much of America. So saying all these things are obvious violations of the Equal Protections Act, and they are not constitutional, but they did happen, and we have to reckon with that. After Plessy, American courts labored with the doctrine of separate but equal for over half a century. Brown v. Board of Education, all right, so it's just referring to this case, Brown v. Board of Education. Some cases in this period attempted to curtail the perniciousness of the doctrine by emphasizing that it required states to provide Black students educational opportunities equal to, even if formally separate from, those enjoyed by white students. So referring to another case here, Missouri, Gaines v. Canada. But the inherent folly of that approach of trying to derive equality from inequality soon became apparent. As the court subsequently recognized, even racial distinctions that were argued to have no palpable effect worked to subordinate the afflicted students. And so, referring to this case, here we have McLaurin v. Oklahoma State Regents for Higher Ed. By 1950, The inevitable truth of the 14th Amendment had thus begun to reemerge. Separate cannot be equal. And this is something that we talked about again when all the vaccine passport stuff came out, right? Or even didn't have to be the vaccine passports, but just if you had the vaccine, you didn't have to test. If you didn't, you had to test, or you had to wear the mask, or they had two sets of rules based on your vaccination status or some medical status, right? Separate cannot be equal. Under the eyes of the state. Just not. The culmination of this approach came finally in Brown v. Board of Ed. There, the court overturned the separate but equal regime established in Plessy and began on the path of invalidating all de jure racial discrimination by the states and federal government. Because again, it was the states, it was the governments that enforced this discrimination. So I think it's interesting that we're saying like, okay, you enforce this segregation. Now we're going to ask you to make sure that there is no racism. So that logic, it doesn't quite make sense in my head. The conclusion reached by the Brown Court was unmistakably clear. The right to a public education must be made available to all on equal terms. The court reiterated that rule just 1 year later, holding that full compliance with Brown required schools to admit students on a racially non discriminatory basis. In the years that follow, Brown's fundamental principle that racial discrimination in public education is unconstitutional, it reached other areas of life. For example, state and local laws requiring segregation in busing, Gale v. Browder, racial segregation in the employment of public beaches and bathhouses, Mayor and City Council of Baltimore v. Dawson, and anti-miscegenation laws, Loving v. Virginia. So this is like that you can get married to people of other races. These decisions and others like them reflect the core purpose of the Equal Protection Clause, doing away with all governmentally imposed discrimination based on race. And then just referring to another case, Palomar v. Sidoti. Eliminating racial discrimination means eliminating all of it. Accordingly, the court has held that the Equal Protection Clause applies without regard to any differences of race, of color, or nationality, and it's universal in its application. Yick Woe v. Hopkins. For the guarantee of equal protection cannot mean one thing when applied to one individual, and something else when applied to a person of another color. That's from Regents of University of California v. Back. Any exceptions to the Equal Protection Clause guarantee must survive a too daunting step examination known as strict scrutiny. Ireland Constructors v. Inc. Pena. So I guess that's where this test came from. And it asks first whether racial classification is used to further compelling governmental interests, Grutter v. Bollinger, and second, whether the government's use of race is narrowly tailored, i.e., necessary to achieve that interest, Fisher v. University of Texas at Austin. So again, those two things. So you can't you can't violate the Equal Protection Clause, except if you can pass this two-part test of strict scrutiny, right? The first part would be that if it's for a compelling government interest. And so again, this is where I sort of am like, wasn't it like a compelling government interest just a while ago to segregate people, right? So I question what the compelling government interest could be in any case. And then the other part of the test is that it's narrowly tailored. Let's keep going. Acceptance of race based state action is rare for a reason. Distinctions between citizens solely because of their ancestry are, by their very nature, odious to a free people whose institutions are founded upon the doctrine of equality. Right? I'll read that one more time. Distinctions between citizens solely because of their ancestry are, by their very nature, odious to a free people whose institutions are founded upon the doctrine of equality. And that's from a case Rice v. Uh, Cayetano. All right, C. So up to our third kind of sub reason for the court's decision here. This court first considered whether a university may make race based decisions in back 438 US 265. In a deeply splintered decision that produced 6 different opinions, Justice Powell's opinion for himself alone would eventually come to serve as the touchstone for constitutional analysis of race conscious admissions politics. After rejecting three of the university's 4 justifications as not sufficiently compelling, Justice Powell turned to its last interest, asserted to be compelling, obtaining the educational benefits that flow from a racially diverse student body. So apparently in this case there was 4 reasons, 3 of them were not compelling, but the fourth reason found to be compelling was basically saying that it's good to go to school with people who are racially diverse. So that's why we're going to have affirmative action. Justice Powell found that interest to be a constitutionally permissible goal for an institution of higher education, which was entitled as a matter of academic freedom to make its own judgments as to the selection of its student body. And I'm actually inclined to this argument, right? Unless it is a state university, right? So if it's a state university or, a city university that's funded by the government, that's taxpayer funded, I don't think that they should be able to. But if it's a private institution, I don't see why not. Personally, I don't see why a private institution shouldn't be able to decide what their criteria are for admissions. Maybe they're race based, maybe they're you can be a legacy or a student athlete or what have you. So I'd definitely be interested to see if they uh, address that. But a university's freedom was not unlimited. uh, Racial and ethnic distinctions of any sort are inherently suspect, Justice Powell explained, and antipathy towards them was deeply rooted in our nation's constitutional and demographic history. Accordingly, a university could not employ a 2-track quota system with specific number of seats reserved for individuals from a preferred ethnic group. Neither still could a university use race to foreclose an individual from all consideration. Race could only operate as a plus in a particular applicant's file. And even then, it had to be weighted in a manner flexible enough to consider all pertinent elements of diversity in light of the particular qualifications of each applicant. I mean, to me, this is just where it starts to get nonsensical, right? You can use race this much, but not this much. It has to be here. It's so subjective and it's just so tedious. It just all seems like so bureaucratic and so silly. Like it just it's like watching a school board meeting. It's so frustrating, They may or may not be competent, but just the nature of what they're doing is so ridiculous that some of this gets to that level. I'm not trying to, the Supreme Court does important work. The law is important. These things are important, but I just feel like some of the things, I guess, that we ask the government to do, it just seems like, well, what did you expect the response to be when you ask the government to do it? All right, D. For years following back, lower courts struggled to determine whether Justice Powell's decision was binding precedent. Grutter, uh, then Grutter v. Bollinger, the court for the first time endorsed Justice Powell's view that student body diversity is a compelling state interest that can justify the use of race in university admissions. The Grutter majority's analysis tracked Justice Powell's in many respects, including in its insistence on limits on how universities may consider race in their admissions programs. So they're saying, yeah, you can use race, but we have some limits on how you can do that. Those limits, Grutter explained, were intended to guard against two dangers that all race based government action pretends. The first is the risk that the use of race will devolve into illegitimate stereotyping. And I mean, in my opinion, that slope is super slippery. You get there really quickly. And then so it says admissions program could thus not operate on the belief that minority students always or even consistently express some characteristic minority viewpoint on any issue. The second risk is that race would be used not as a plus but as a negative to discriminate against those racial groups that were not beneficiaries of the race-based preference. A university's use of race accordingly could not occur in a manner that unduly harmed non-minority applicants. To manage those concerns, Grutter imposed one final limit on race-based admissions programs. At some point, the court held they must end. Right? And this is something I talked about in the beginning. At some point, the court held they must end. And so this has always been baked in. And I guess the court has sort of decided that now is that time. Recognizing that enshrining a permanent justification for racial preferences would offend the Constitution's unambiguous guarantee of equal protection. The court expressed its expectation that in 25 years, the use of racial preferences will no longer be necessary to further the interest approved today. So 25 years. I don't remember exactly what year Grutter happened in, but let's see. We can look it up real quick. Grutter SCOTUS. So 2003. So it hasn't been quite 25 years since this specific decision, but almost. It's been 20 years. So 5 years shy. All right, E. Oh, there's my answer right there. 20 years have passed. 20 years have passed since Grutter, with no end to race-based college admissions in sight. But the court has permitted race-based college admissions only with the confines of narrow restrictions. Such admissions programs must comply with strict scrutiny, may never use race as a stereotype or negative, and must at some point end. Respondents' admissions systems fails each of these criteria must therefore be invalidated under the Equal Protection Clause of the 14th Amendment. So even if you so it actually doesn't seem like the original, or maybe it has, we'll get there, but they're saying even under just strict scrutiny, right, even under the standard of that affirmative action had set in place under Grutter 20 years ago, it fails on the count that never uses a negative stereotype. I guess the strict scrutiny had the two parts of that, it had to be to the government's interest, which I guess it would pass that part of it, but maybe the next part, right? The next part of strict scrutiny is that it's narrowly tailored. And at the beginning, we read through how race was used in each of these, and it seemed to be in many parts of the admissions process. So perhaps that wasn't narrow enough to pass strict scrutiny. We'll see if they go more into that. All right. 1. Respondents fail to operate their race-based admissions program in a manner that is sufficiently measurable to permit judicial review under the rubric of strict scrutiny. So they are going to go into this and explain it a little more. First, the interest that respondents view as compelling cannot be subjected to meaningful judicial review. Those interests include training future leaders, acquiring new knowledge based on diverse outlooks, promoting a robust marketplace of ideas, and preparing engaged and productive citizens. While these are commendable goals, they are not sufficiently coherent for purposes of strict scrutiny. It is unclear how courts are supposed to measure any of these goals or if they could to know when they have been reached so that racial preferences can end. So they're nice words is what they're saying, but they don't mean anything in a way that we can measure or understand or yeah, and that's how I feel I think about a lot of the equity, diversity, inclusion stuff is I don't disagree with a lot of the words that they're saying or a lot of the ideals or even with a lot of the goals. But it's then the like how do we measure that? Like what does that actually look like in practice? It seems to be so subjective as to not really mean anything at all and just be able to then allow whose ever interests and whoever has the most power at that time sort of push their agenda through rather than have sort of an objective set standard. So it's unclear how courts are supposed to measure any of these goals. Yeah, oppression is supposed to end. Okay. The elusiveness of respondents' asserted goals is further illustrated by comparing them to recognized compelling interests. For example, the court can discern whether the temporary racial segregation of inmates will prevent harm to those in prison. See Johnson v. California. But the question whether a particular mix of minority students produces engaged and productive citizens or effectively trains futures leaders is standardless. So you would have to, I guess, go into this case and see um, why it would pass strict scrutiny to segregate inmates. My guess would have to do with gangs, and a lot of gang violence is race based. You know, you go in a gang that is from your neighborhood or from the people who look like you. You know, we know we have the famous white supremacist gangs, and then I guess we have our what's that one from like Venezuela, I don't think it's Latin Kings, but Latin Kings is another one. And then, you have your Bloods and your Crips. So I would say that's probably how it passes strict scrutiny in that case, whereas it's less clear. Um, I personally do think that representation matters. I do think that being around people of other races matters, that when you get to interact with people, I don't think anybody disagrees with that. I don't think anybody disagrees that being around people of other cultures and other races and makes you a more open-minded person and empathetic and understanding person. So, but again, how do you measure it in the sense of like, all right, we need to end these policies that use race so heavily? And when are we to the point as a society where we just genuinely value that thing? And we might not get it perfect. Like there's going to be choice, and people still do. As in New York City, I talk about this, how the communities are segregated not because of systemic racism per se. I mean, there could be some systemic things certainly, but people just like to live with their people, right? Like when you come over as an immigrant, you're going to move into a community of people who speak your same language, who can help you make the transition. So all right, let's get back into this because, like I said, we're making good headway through here. I think. Well, I thought we were a little further on page 7. Let's keep going. Second, respondents' admissions program failed to articulate a meaningful connection between the means they employ and the goals they pursue. To achieve the educational benefits of diversity, respondents measure the racial composition of their classes using racial categories that are plainly overbroad, expressing, for example, no concern whether South Asian or East Asian students are adequately represented as Asian. Arbitrary or undefined, the use category of Hispanic or under inclusive, no category at all for Middle Eastern students. There unclear connection between the goals that respondents seek and the means they employ to preclude courts from meaningfully scrutinizing respondents' admissions programs. So, all great points about the arbitrary nature of some of these labels and trying to come up with the appropriate labels. And again, just when you try to include everyone or make a special category for everyone, you're going to be excluding someone versus just saying, come one, come all, and we'll choose the best based on, you know, who can pass the test or who can get the best grades or whatever your standards are. The university's main response to these criticism is trust us. And again, I'm inclined to. If it's a private university, I frankly don't care. Like, if you want to admit all black students, like you want to be a black university, and like, go for it. Like, I mean, it gets a little weirder, I guess, when you're saying like an all white university, because I think white is one of those categories that doesn't make sense in the same way that black does. I think that it's like you might have an Italian university or um, you know, Jewish university. I think things like that are much more equivalent to black than white, right? White is like saying Asian in a way. It's like Asian is so diverse. South Asian, East Asian, you know, West Asian. Let's see. They assert that universities are owed deference when using race to benefit some applicants but not others. While this court has recognized the tradition of giving a degree of deference to a university's academic decisions, it has made clear that the deference must exist within constitutionally prescribed limits. Again, from Grutter. Respondents have failed to present an exceedingly persuasive justification for separating students on the basis of race that is measurable and concrete enough to permit judicial review, as the Equal Protection Clause requires. Respondents' 2. Respondents' race-based admission system also fails to comply with the Equal Protection Clause twin commands that race may never be used as a negative and that it may not operate as a stereotype. The First Circuit has found that Harvard's consideration of race has resulted in fewer admissions of Asian American students. Respondents' assertion that race is never a negative factor in their admissions program cannot withstand scrutiny. College admissions are zero sum, and benefits provided to some applicants but not to others necessarily disadvantage the former at the expense of the latter. So they're basically saying that, like, okay, you might be considering, if you go back to the beginning when they were making determinative decisions based on race, like you might be putting some kid in because of their race. And even though you're not putting that, we're not putting that Asian student in. That's not exactly what they're doing. By default, that is what's happening. And therefore, it doesn't withstand strict scrutiny. College admissions are zero sum. Oh yeah, we read that. Okay, respondents admissions programs are infirm and for a second reason as well. They require stereotyping, the very thing Grutter foresaw. When a university admits students on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, think alike. Miller v. Johnson. Such stereotyping is contrary to their core purpose. Right? So it's basically saying that, like, okay, we're using this kid's race, like if they're a Hispanic student, oh, and they're going to get in. That's going to be the determinative factor to get it in. That's because you're making certain assumptions about Hispanic people, or if you're making certain assumptions about Black people, that's why you're determining they should go in over somebody else. I think it also is, and I'll wonder if they get there, it's just assuming that if they didn't have their race, they wouldn't be able to get up to that standard. I think there was literally people out there saying that if Black people or people of color, so Hispanic people, Native people, if they don't have this, then they'll never be able to compete in merit-based system. That's just like, what? Did you hear what you said? Did you read what you did you read what you typed on the screen? Like, um, all right, so we're up to 3. Respondents' admissions program also lack a logical endpoint, as Grutter required. Respondents suggest that the end of race-based admissions program will occur once meaningful representation and diversity are achieved on college campuses. Such measures of success amount to little more than comparing the racial breakdown of the incoming class and comparing it to some other metrics, such as the racial makeup of the previous incoming class or the population in general, to see whether some proportional goal has been reached. The problem with this approach is well established. Outright racial balancing is patently unconstitutional. So, respondents' second proffered endpoint, when students receive the educational benefits of diversity, fares no better. As explained, it's unclear how a court is supposed to determine if or when such goals would be adequately met. Third, respondents must suggest the 25-year expectation in Grutter means that race-based preferences must be allowed to continue until at least 2028. The court's statement in Grutter, however, reflected only that the court's expectation that race preferences would by 2028 be unnecessary in the context of racial diversity on college campuses. Finally, right? So it's saying like it did, just because they said that that was their expectation doesn't mean that it had to be that day. It could be before, it could be after. Finally, respondents argue that the frequent reviews they conduct to determine whether racial preferences are still necessary obviate the need for any endpoint. But Grutter never suggested that periodic review can make unconstitutional conduct constitutional. F. Because Harvard and UNC's admissions program lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. Those admissions programs cannot be reconciled with the guarantee of the Equal Protection Clause. At the same time, nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to the quality of character or unique ability of that particular applicant can contribute to the university. So this is a great point, saying that, hey, a kid could write in their essay how their race influenced their life and help them to do this great thing. Or, again, it's going back to the merit, though, not just the race in and of itself. Many universities have for too long wrongly concluded that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. This nation's constitutional history does not tolerate that choice. Right? So again, they're assuming based on the color of the skin that one has gone through these experiences, which they may or may not have. So they're reversing the decision from the lower court, and this decision was Roberts made this, and Alito signed on, Gorsuch signed on, Kavanaugh signed on, and Barrett signed on, and also Thomas. So there's a oh no, these are saying other people did. Oh, okay, got it. And then, like I said, there's other concurring opinions. So that's what I was starting to read there. But we're going to go up to page 140. So there's over 100 pages of concurring opinions. And we're going to go to the dissenting opinion, which is written by Justice Sotomayor, who is from not too far from here where I am in Connecticut. She's from the Bronx, and she is writing with whom Justice Kagan and Justice Jackson joined in dissenting. So they voted against the overturning it, and they think that affirmative action is still necessary, that the time has not yet expired, and perhaps they have some other arguments where they do think it passes strict scrutiny. So I'm definitely interested, and I think it's so important to know both sides, to know the arguments that both sides are making, and to truly understand them. Because you might agree with one thing, but then you hear the other side and you're like, oh, I didn't think about that thing. And I actually, you know what? I don't think that the opinion I agree with considers this fully, or I actually think maybe they're right out wrong. They're just wrong. Or maybe it just reinforces how much you do believe with the first one. So it's super important to get both sides. And I really think that it shows how thoroughly that these justices are thinking about these ideas and how much they truly do try to ground them in the legal precedent and in the Constitution itself. Whereas when you get to the political arena, it's just so disconnected from any of these ideas, from any serious conversation at all, right? We can disagree with perhaps what Justice Sotomayor thinks, or Kagan, or Jackson, or on the other side, maybe you disagree with the initial opinion, but you can at least respect them for the thought process that they go through, and for, in good faith, engaging in it. So, yeah, I'm definitely interested to see what the other side is saying, and what the justifications are for why we might still need affirmative action. All right. So, the Equal Protection Clause of the 14th Amendment enshrines a guarantee of racial equality. So, again, starting with that Equal Protection Clause, 14th Amendment, the court long ago concluded that this guarantee can be enforced through race conscious means in a society that is not and has never been colorblind. So, even though we have this in the original Constitution, or not the original Constitution, but an amendment which is from what, the 1860s, 70s, right? It was created in that time, post Civil War. So, pretty long time ago. Um, and we saw, even as admitted in the court's opinion, that there was a long period of time after we had the Equal Rights Amendment that it didn't matter, right? We had Jim Crow and all sorts of discrimination. And so what she's saying is that we to enforce that, we need to have race conscious legislation. Otherwise, we never would have ended those things. That seems to be the main part of our argument. In Brown v. Board of Education, the court recognized the constitutional necessity of racially integrating schools in the light of the harm inflicted by segregation and the importance of education in our democratic society. For 45 years, the court extended Brown's transformative legacy to the context of higher education, allowing colleges and universities to consider race in a limited way and for a limited purpose of promoting the important benefits of racial diversity. This limited use of race has helped equalize educational opportunities for all students of every race and background, and has improved racial diversity on college campuses. Although progress has been slow and imperfect, race conscious college admissions policies have advanced the Constitution's guarantee of equality and have promoted Brown's vision of a nation with more inclusive schools. So, again, I think it's interesting here that she seems to use much less like textual quote references, and she's doing a little bit more like narration of the legacy of Brown. Just what I'm noticing. Today, this court stands in the way and rolls back decades of precedent and momentous progress. It holds that race can no longer be used in a limited way in college admissions to achieve such critical benefits. In so holding, the court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. So, this is a statement here that I don't know if I fully I agree with some of it and I disagree with other parts of it. So, I disagree that we are in an endemically segregated society. So, a pandemic is like when things are acutely spreading all over the world. Endemic is when it becomes sort of like seasonal. So like every year it comes back, right? Like the flu, it's an endemic virus. So that's what she's saying is like racism in here. It might not be at that acute, like that pandemic form, but it's in our society and it's always going to be something that we deal with. And I guess for me, I don't agree with the word endemic. I think that makes it seem more again, I don't want to say there isn't racism. I think it matters, representation matters, and I certainly think that there is racism both on an individual basis and at the hands of institutions, whether they be governments or corporations. Um, but this notion that we'll always need the government to cut like the government to know better. It just doesn't make sense to me when the government is the, the ones who so often seem to be enforcing this as well. So the court subverts the constitutional guarantee of equal protection by further entrenching racial inequality in education, the very foundation of our democratic government and pluralistic society. Because the court's opinion is not grounded in law or fact and contravenes the vision of equity embodied in the 14th Amendment, I dissent. So she is going to go on to state her reasons. I do still think it's interesting that there are very few actual quotes from any of these cases, whereas in the court's opinion, it seemed that there was lots of lots of quotes, lots of references to all sorts of different cases throughout history. So, 1A. Equal education opportunity is a prerequisite to achieving racial equality in our nation. From its founding, the United States was a new experiment in a republican form of government where democratic participation and the capacity to engage in self-rule were vital. At the same time, American society was structured around the profitable institution that was slavery, which the original Constitution protected I might dispute that. I would, we'll see what the Constitution initially limited the power of Congress to restrict the Slave Act. Right. I mean, it said that they couldn't do it until a certain date. That was a compromise it made. So, sure, it protected it for a certain until 1808, and then right in 1808 or 1807 or 1808, um they ended the slave trade as soon as they could. Um I think that it was a compromise that sort of needed to be made in the short term so that they could form the republic and then deal with that later on, knowing that the foundational principles of all men being created equal obviously contradict that. One man can be owned by another. And I think that American history certainly bears that out. Again, a conversation that we can have more at length once we get through this reading of this, perhaps in another stream. Accorded Southern states additional electoral power by counting 3/5 of their enslaved population and apportioning congressional seats. All right, so I think that she does make a fair argument here about how the Constitution did, in some ways, protect the institution of slavery. Though I think that, like, I would sort of flip that in the other way and say it was a compromise that they made in the short term, but really set up ways for these things to end, right? They was a clear pathway, which was within 80 years of the country's founding, to slavery ending. Because the foundational pillar of slavery was the racist notion that Black people are a subordinate class with intellectual inferiority, Southern states sought to ensure slavery's longevity by prohibiting the education of Black people, whether enslaved or free. See H. Williams' self-taught African American education slavery in freedom. So I think it's interesting that she's not referencing another court case here. She's referencing a book, which again, it may be a good book. I mean, I think that she makes a fair point. I might kind of want to parse out some of the specifics of the statement, but I more or less agree with it, and it seems like it could be a good book. I just think it's interesting to reference a book rather than a legal case. From this nation's birth, the freedom to learn was neither colorblind nor equal. I agree with that. With time, and at the tremendous cost of the Civil War, abolition came. More than 2 centuries after the first African enslaved person were forcibly brought onto our shores, Congress adopted the 13th Amendment to the Constitution, which abolished slavery and involuntary servitude except as a punishment for crime. Like all great historical transformations, emancipation was a movement, not a single event owed to any single individual, institution, or political party. So again, she's referencing a book here, the second founding, rather than um, a case. The fight for equal education opportunity, however, was a key driver. Literacy was an instrument of resistance and liberation. Self-taught aid. Uh, I don't disagree with that either. I think that if you read which we need to finish up. I have another stream, the autobiography of Frederick Douglass. He also talks a lot about that. It allowed enslaved Black people to disturb the power relations between master and slave, right? Frederick Douglass said when his slave told him that the reason he didn't want him to learn is because he'd realize like all these things about wanting to be free, he was like, oh, thank you for that piece of information. Now I'm going to do everything I can to learn to read. Put simply, the very feeling of inferiority which slavery forced upon Black people fathered an intense desire to rise out of their condition by means of education. W.E. Du Bois, Black Reconstruction in America. Okay, so again, that's just a reference to another book. Black Americans thus insisted, in the words of Frederick Douglass, right? Told you just reference Frederick Douglass, that in a country governed by people like ours, education of the youth of all classes is vital to its welfare, prosperity, and to its existence. Addressed to the people of the United States. The life and writings of Frederick Douglass. Black people's yearnings for freedom of thought and for a more perfect union with educational opportunity for all played a crucial role during the Reconstruction era. Yet, emancipation marked the beginning, not the end of that era. Abolition alone could not repair centuries of racial subjugation. Following the 13th Amendment's ratification, the Southern states replaced slavery with a system of laws which imposed upon Black people onerous disabilities and burdens and curtailed their rights in the pursuit of life, liberty, and property to such the extent that their freedom was of little value. Regents of University of California v. Back. All right, so we have a reference to a case that we heard a lot of in the opinion of the court. Those so-called black codes discriminated against black people on the basis of race, regardless of whether they had been previously enslaved. Moreover, the criminal punishment exception in the 13th Amendment facilitated the creation of a new system of forced labor in the South. Southern states expanded their criminal laws, which in turn permitted involuntary servitude as punishment for convicted black persons. D. Blackman Slavery was another name. So another book, Slavery by Another Name. States required, for example, that black people sign a labor contract to work for white employer or face prosecution for vagrancy. In second founding 48, state laws then forced black convicted persons to labor plantations, mines, and industries in the South. This system of freed forced labor provided tremendous benefits, to Southern whites and was designed to intimidate, subjugate, and control newly emancipated black people. So again, the book, the 13th Amendment, without more, failed to equalize society. So again, I think that this history is more or less accurate, and it was confronted. That's why it's interesting to read both sides, because in the court's opinion, this history was confronted in one way, certainly much less depth, though a fair job, I would say. And then this one is going really deep into the history by making references to all sorts of literature and not as many court cases necessarily, though perhaps they're coming since we're not there yet. All right. Congress thus went further and embarked on 2 months of deliberation about additional Reconstruction laws. Those efforts included the appointment of a committee, the Joint Committee on Reconstruction, to inquire the condition of the Confederate States. Reported the Joint Committee on Reconstruction. Okay. Among other things, the committee's report to Congress documented the deep-seated prejudice against emancipated black people in southern states and the lack of general disposition to place the colored race, consisting at least 2/5 of the population, upon terms even of civil equality. In light of its findings, the committee proposed amending the Constitution to secure the equality of rights and civil and political. Congress acted on that recommendation and adopted the 14th Amendment. Proponents of the amendment declared that one of its key goals was to protect the black man and his fundamental rights as a citizen with the same shield with which it throws over the white man. That is, the amendment sought to secure a race recently emancipated, a race that through many generations was held in slavery, all the civil rights that superior race enjoyed. And this is the Plessy v. Ferguson decision. So interesting that she references that decision as almost being a positive thing, saying like, hey, like we need this separate but equal thing. To promote this goal, Congress enshrined a broad guarantee of equality under the Equal Protection Clause of the 14th Amendment. That clause commands that no state shall deny to any person within its jurisdiction the equal protection of the law. Congress chose its words carefully, opting for expansive language that focused on equal protection and rejecting proposals that would have made the Constitution explicitly colorblind. All right, I think this is important. We're going to read that again. So, Congress chose its words carefully, opting for expansive language that focused on equal protection and rejecting proposals that would have made the Constitution explicitly colorblind. All right, interesting. I wish she would have. Let's see if she provides more examples of what she means by this. Rejecting proposed language that provided no state shall recognize any distinction between citizen on account of race or color. So, okay, so it rejected this language, which she's saying is language of colorblind. Okay, so and instead they went, no state shall deny to any person with its jurisdiction equal protection of the laws. Okay. This choice makes it clear the 14th Amendment does not impose a blanket ban on race conscious policies. So, okay, so she's saying because they didn't choose to use this specific language on account of race or color, that means that it's not supposed to be totally unrace conscious. Though one might argue that they just didn't want to limit it to race or color. That's why they just said any persons, right? Because I mean, technically it could be like sexual orientation or religion or age, any number of categories. But this is the argument she's making. Simultaneously, with the passage of the 14th Amendment, Congress enacted a number of race conscious laws to fulfill the amendment's promise of equality, leaving no doubt that the Equal Protection Clause permits consideration of race to achieve its goals. One such law was the Freedmen's Bureau Act, enacted in 1865 and then expanded in 1866, which established a federal agency to provide certain benefits to refugees and newly emancipated freemen. For the Bureau, education was the foundation upon which all of its efforts to assist the freemen rested. Consistent with that view, the Bureau provided essential funding for Black education during Reconstruction. Black people were targeted beneficiaries of the Bureau's programs, especially when it came to investment in education in the wake of the Civil War. Each year surrounding the passage of the 14th Amendment, the Bureau educated approximately 100,000 students, nearly all of them Black, and regardless of degree of past disadvantage. All right. The Bureau also provided land and funding to establish some of our nation's historically Black colleges and universities. In 1867, for example, the Bureau provided Howard University tens of thousands of dollars to buy property and construct its campus in our nation's capital. Howard University was designed to provide special opportunities for higher education to newly enfranchised of the South, but it was available to all Black people, whatever may have been their previous condition. The Bureau also expended a total of $400,752.21 on Black colleges and only $3,000 on white colleges from 1867 to 1870. Indeed, contemporaries understood that the Freedmen's Bureau Act benefited Black people. Supporters defended the law by stressing its race-conscious approach. The true object of this bill is the amelioration of the condition of the colored people. I mean, it sounds a little bit like reparations to me, which I think, if we talk about it in the framework of reparations, and, we may or may not argue that it was sufficient to fulfill the reparations that were deserved. But when we're talking about, one party repairing the other, this sounds much more close to that. Like when we talk about reparations today, it's really hard for me to understand like who's repairing who. And what type of precedent does that set like for future grievances? Whereas this, it doesn't seem so much again as being like a race conscious never ending policy. It seems more about like reparations, saying like, okay, these people were harmed, so we're going to have a very limited policy from this one generation, to restore them in these ways. Opponents argue that the act created harmful racial classifications that favored Black people and disfavored white Americans. Let's see. Okay, all these parentheses are confusing. You raise a spirit of antagonism between Black race and the white race in our country. The law buying will be powerless to control it. Okay, and President Andrew Johnson vetoed the bill on the basis that it provided benefits to a particular class of citizens. thus rejecting those opponents' objections. The same Reconstruction Congress that passed the 14th Amendment eschewed the concept of blindness as sufficient to remedy inequality in education. And I think that if we are going to sort of accept the premise of the argument that's being used for affirmative action, it makes much more sense in the context of Reconstruction than it does in 2023, right? And so it's hard to draw a straight line. It's hard to argue that we still need it in the same way that we might have after the 14th Amendment, I think. Again, I would love to know what you think. Let me know in those comments. Trying to reserve my own opinion as much as possible, but I am providing my opinion, trying to make it clear where it is my opinion. I think that I've been fair to both, saying where I agree with things or disagree with things. And I found a lot where I certainly agree with Sotomayor's description of certain aspects of history, but not always how she's applying them to her understanding of this situation, I would say. Though, like I said, I'm just a little bit like cynical in general to this kind of stuff. Like it doesn't seem like the private university, Harvard, I don't care how Harvard does their admissions. They should be able to do their admissions however they want to. They're a private university. A public university, to me, it's pretty obvious that they shouldn't be able to do that. But I guess, if we're talking about the narrowly tailored standard scrutiny, it's like, all right, let's keep going. There is a debate to be had, I think. I certainly think that there is a debate to be had that you wouldn't have any idea about if you're just on social media or reading mainstream news. All right, Congress also debated and passed the Civil Rights Act of 1866 contemporaneously with the 14th Amendment. The goal of that act was to eradicate the black codes enacted by Southern states following the ratification of the 13th Amendment. Because the black codes focused on race, not just slavery-related status, the Civil Rights Act explicitly recognized that white citizens enjoyed certain rights that non-white citizens did not. Section 1 of the act provided that all persons of every race and color shall have the same rights and those enjoyed by white citizens. This is 1866. Similarly, Section 2 established criminal penalties for subjecting racial minorities to different punishment by reason of race or color than prescribed for punishments of white persons. In other words, the act was not colorblind. By using white citizens as a benchmark, the law classified by race and took account of privileges enjoyed by only white people. As he did with the Freedmen's Bureau Act, President Johnson vetoed the Civil Rights Act, in part because he viewed it as providing black citizens with special treatment. So it seems to me, honestly, like this is kind of like against her argument. She's saying like, oh, hey, they tried to make this law, but actually it was overturned because it was seen as not being constitutional. So, So it's designed to afford discriminating protection to colored persons, and its distinction of race and color operates in favor of colored and against the white race. I guess this is specifically what he said when he vetoed it. Again, Congress overrode his veto. Okay, I see. So they overrode the veto. So Congress you're right. She is making the right argument here. Sorry, I misread that. It's getting late. Right? So Congress was sort of saying that they think it is right to use race and to distinguish between the two races. Several times during and after the passage of the 14th Amendment, Congress also made special appropriations and adopted special protections for the bounty and prize money owed to colored soldiers and sailors of the Union Army. In doing so, it rebuffed objections to these measures as class legislation applicable to colored people and not to the white people. This history makes it inconceivable that race-conscious college admissions are unconstitutional. So, and she is referring to Beck. The Reconstruction era marked a transformational point in the history of American democracy. Its vision of equal opportunity leading to an equal society was short-lived, however, with the assistance of this court. In a series of decisions, the court sharply curtailed the substantive protections of the Reconstruction Amendments and the Civil Rights Act. The endeavor culminated with the court's shameful decision in Plessy v. Ferguson. Okay, so there we go. Which established that equality of treatment exists when the races are provided substantially equal facilities, even though these facilities be separate. Therefore, with this court's approval, the government enforced segregation and its commitment and its concomitant destruction of equal opportunity became the constitutional norm and infected every sector of our society, from bathrooms to military units and, crucially, to schools. In a powerful dissent, Justice Harlan explained in Plessy that Louisiana law at issue, which authorizes segregation of railway carriages, perpetuated a caste system. Although the state argued that the law prescribed a rule applicable alike to white and colored citizens, all knew that the law's purpose was not to exclude white persons from railroad cars occupied by blacks, but to exclude colored people from coaches occupied or as assigned to whites. That is, the law proceeded on the ground that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens. Although the white race deemed itself to be the dominant race in prestige and advancements in education and wealth and in power, Justice Harlan explained, there is no superior dominant ruling class of citizens in the eyes of the law. In that context, Justice Harlan thus announced his view that our Constitution is colorblind. Oh, he did announce that it's colorblind. It was not until a half century later in Brown that the court honored the guarantee of equality in the Equal Protection Clause that Harlan's vision of the Constitution that neither knows nor tolerates classes among citizens. Considering the effects of segregation and the role of education in light of the full development and its presented in American life throughout the nation, Brown overruled Plessy. The Brown court held that separate education facilities are inherently unequal and that such racial segregation deprives black students of equal protection of the laws guaranteed by the 14th Amendment. The court thus ordered schools segregated to transition to racially integrated system of public education with all deliberate speed, ordering the immediate admissions of black children to schools previously attended only by white children. Brown was a race-conscious decision that emphasized the importance of education in our society. Central to the court's holding was the recognition that, as Justice Harlan emphasized in Plessy, segregation perpetuates a caste system wherein black children receive inferior education opportunities solely because of their race, denoting inferiority as to their status in the community. Moreover, because education is the very foundation of good citizenship, segregation in public education harms our democratic society more broadly as well. In light of the harmful effect of entrenched racial subordination on racial minorities in American democracy, Brown recognized the constitutional necessity of racially integrated systems of school where education is available to all on equal terms. The desegregation cases that followed Brown confirmed that the ultimate goal of the seminal decision was to achieve a system of integrated schools that ensured a racial equality of opportunity, not to impose a formalistic rule of colorblindness. In Green v. School BD of New Kent City, for example, the court held that the New Kent City School Board's freedom of choice plan, which allegedly allowed every student, regardless of race, freely to choose the school he would attend, was insufficient to effectuate the command of Brown. That command, the court explained, was that schools dismantle well-entrenched dual systems and transition to a unitary, non-racial system of public education. That the board opened the doors of the former white school to black children and the black school to white children on the race-blind basis was not enough. Passively eliminating race classifications did not suffice when de facto segregation persisted. So they're basically saying that you can't just offer school choice. You can't say, oh, sign up for the school that you wanted. And it just so happened that most of the white kids went to the school and most of the black kids went to the school. No, like you have to have integrated schools. Um, Noting that 85% of black children in the school system were still attending an all black school. Instead, the board was clearly charged with um, the affirmative duty to take whatever steps might be necessary to convert a unitary system with racial discrimination in which racial discrimination would be eliminated, root and branch. Affirmative steps this court held are constitutionally necessary when mere formal neutrality cannot achieve Brown's promise of racial equality. So holding that North Carolina statute that forbade the use of race in school busing exploits an apparently neutral form to control school assignment plans by directing that they be colorblind. That requirement against the background of segregation would render illusory promise of Brown. So again, holding that the North Carolina statute that forbade the use of race in school busing exploits an apparently neutral form. Not sure what that means. Okay, the state automatically assumes an affirmative duty under Brown to eliminate the vestiges of segregation. In so holding, this court's post Brown decisions rejected arguments advanced by opponents of integration, suggesting that restoring race as a criterion in the operation of public schools was at odds with the Brown decision. Suggesting that restoring race as a okay. The opponents argued that Brown only required the admissions of black students to public schools on racially non-discriminatory basis. Relying on Justice Harlan's dissent in Plessy, they argued that the use of race is improper because the Constitution is colorblind, right? Which is why I was confused, because I thought that that's what Harlan said, and yet she seemed to be endorsing his view even though she's against colorblindness. So some of this is a little bit confusing to me about like what is her side and what is exactly her argument. Maybe it'll all become clear when she comes to her conclusion, but I, I'm trying to keep track of the needle she's threading here. They also incorrectly claimed that their views aligned with those of the Brown litigators, arguing that Brown plaintiffs understood that Brown's mandate was colorblindness. So I'm not sure. I don't have the context to know if that's right or not. This court rejected characterization of the thrust of Brown. It made clear that the indifference to race is not an end in itself under the watershed decision. The ultimate goal is racial equality of opportunity. So it sounds nice. It does. Those rejected arguments mirror the court's opinion today. The court claims that Brown requires that students be admitted on racially non-discriminatory basis. It distorts the dissent in Plessy to advance a colorblind theory. But I thought he said that he does believe in colorblind theory. Today's decision makes the echoes of Justice John Marshall Harlan in Plessy. So that's such a I don't understand. Wait, 22, Gorsuch. I don't know what some of these parentheses mean and what it's referring to. It distorts the Plessy to advance colorblindness theory. Today's decision wakes the echoes of Justice John Marshall and Plessy. The court also invokes Brown litigators relying on what the Brown plaintiffs argued. The court also invokes the Brown litigators plaintiffs argued. Again, I'm not exactly sure what all of these different parentheses and stuff are and who's saying what at what point in time, but trying to grasp the overall argument and keep a big picture view of some of these things. Keep reading through it. I usually find that, don't get bogged down in some of the details. Once you get the bigger picture, you can circle back and dig through it a little bit more. So let's just keep going, and I think we'll get the overall idea of what she's trying to argue. If there was a member of this court who understood the Brown litigation, it was Justice Thurgood Marshall, who led the litigation campaign to dismantle segregation as a civil rights lawyer and rejected the hollow, race ignorant conception of equal protection endorsed by the court's ruling today. Brief for NAACP's Legal Defense and Educational Fund, Justice Marshall joined the back plurality of and applauded the judgment of the court that a university may consider race in its admissions process. In fact, Justice Marshall's view was that backholding should have been even more protective of race-conscious college admissions programs in light of the remedial purpose of the 14th Amendment and the legacy of racial inequality in our society. Arguing that a class-based remedy should be constitutionally permissible in the light of hundreds of years of class-based discrimination against Black Americans. The court's recharacterization of Brown is nothing but revisionist history and an affront to the legendary life of Justice Marshall, a great jurist who was the champion of true equal opportunity, not rhetorical flourishes about color blindness. 2 decades after Brown and back, a plurality of the court held that the attainment of diverse student body is a compelling and constitutionally permissible goal for an institution of higher education. Race could be considered in the college admissions process in pursuit of this goal, the plurality explained. If it is one factor of many in an applicant's file and each applicant receives individualized review as part of a holistic admissions process. Since back, the court has reaffirmed numerous times the constitutionality of a limited race-conscious college admissions. First in Grutter v. Bollinger, a majority of the court endorsed that the back plurality view that the student body diversity is a compelling state interest that can justify the use of race in university admissions. And that and that race may be used in a narrowly tailored manner to achieve this interest. Gratz v. Bollinger. For the reasons set forth the same day in Grutter, rejecting petitioners' arguments that race can only be considered in college admissions to remedy identified discrimination and that diversity is too open-ended, ill-defined, and indefinite to constitute a compelling interest. Later, in Fisher litigation, the court twice reaffirmed that the limited use of race in college admissions is constitutionally permissible if it satisfies strict scrutiny. In Fisher v. University, Texas, Austin. 7 members of the court concluded that the use of race in college admissions comports with the 14th Amendment if it is narrowly tailored to obtain the educational benefits of diversity. And so this is in 2013. So this is 10 years after that case, which had said 20 years later. And so there's 10 years ago, they were like, yeah, we still need race as long as it's narrowly tailored. Back, Grutter, and Fisher are an extension of Brown's legacy. Those decisions recognize that experience lends support to the view that contribution of diversity is substantial. Racially integrated schools improve cross-racial understanding, break down in racial stereotypes, and ensure that students obtain the skills needed in today's increasingly global marketplace through exposure to widely diverse people's cultures, ideas, and viewpoints. I don't disagree with this idea that we need to have, integration. My question is just like, should it be at the behest of the government? Should we be forced to do it, or is it just one of these things that you do realize? Again, I don't think that there's many people out there that you could get to be like, no, I'm against, meeting diverse people of different cultures with all sorts of ideas and viewpoints. Like, nobody says that. So, I don't know what it was like 100 years ago. I don't know if people would be open. I think that there were a lot more explicitly racist or, remarks against one particular culture or people from a certain place. I think that was way more common to have those types of viewpoints. And it's just not now. Not that people don't have prejudices or not that people don't at all, make prejudgments. I'm certainly guilty of doing that as well. More broadly inclusive institutions that are visibly open to talented and qualified individuals of every race and ethnicity instills public confidence in the legitimacy and integrity of institutions and the diverse set of graduates they cultivate. That is particularly true in the context of higher education, where colleges and universities play a critical role in maintaining the fabric of society and serve the training ground for a large number of our nation's leaders. Oh, fabric of society. I don't know what that says about our society. It is thus an objective of the highest order, a compelling interest indeed, that universities pursue the benefits of racial diversity and ensure that the diffusion of knowledge and opportunity is available to students of all races. This compelling interest in the student body diversity is not grounded only in the court's equal protection of jurisprudence, but also in the principles of academic freedom, which long have been viewed as a special concern of the First Amendment. In light of the important purpose of public education and the expansive freedoms of speech and the thought associated with the university environment, this court's precedent recognized the imperative nature of diverse student bodies in American college campuses. Consistent with the First Amendment, student body diversity allows universities to promote the robust exchange of ideas with discoverers, truth out of a multitude of tongues rather than through any kind of authoritative selection. Back. Indeed, the court recently reaffirmed in another school case, learning how to tolerate diverse expressive activities has always been a part of learning how to live in a pluralistic society under our constitutional tradition. And this is Kennedy v. Bremerton School District. And this is a case where a coach was kneeling on the field and praying after football games. And the idea was that he was like bringing religion into school, which was illegal. But the court ruled that actually, for punishing him for praying, they were violating his First Amendment rights. So it's interesting that she brings this case up because I believe she voted she went against that case. So she didn't like that ruling and she's using it here to support her argument. I could be wrong, but I believe she voted against that. In short, for more than 4 decades, it has been this court's settled law that the Equal Protection Clause of the 14th Amendment authorizes a limited use of race in college admissions in service of the educational benefits that flow from a diverse student body. From Brown to Fisher, this court's cases have sought to equalize educational opportunity in a society structured by racial segregation to advance the 14th Amendment's vision of an America where racially integrated schools guarantee students of all races the equal protection of laws. Today, the court concludes that indifference to race is the only constitutionally permissible means to achieve racial equality in college admissions. That interpretation of the 14th Amendment is not only contrary to precedent of the entire teachings of our history, but also grounded in the illusion that racial inequality was a problem of a different generation. Entrenched racial inequality remains a reality today. That is true for society writ at large, and more specifically for Harvard and University of North Carolina, two institutions with a long history of racial exclusion. Ignoring race will not equalize a society that is racially unequal. What was true in 1860 and again in 1954 is true today. Equality requires acknowledgement of inequality. After more than a century of government policies enforcing racial segregation by law, society remains highly segregated. About half of all Latino and Black students attended a racially homogenous school with at least 75% minority student enrollment. The share of intensely segregated minority schools, i.e., schools that enroll 90 to 100% racial minorities, has sharply increased. To this day, the U.S. Department of Justice continues to enter into desegregation decrees with schools that have failed to eliminate the vestiges of de jure segregation. And so, one of the issues I think that they're going to continue to have with this is what we're seeing around here is families are leaving the schools, right? The families that can afford to, and because of the way that race and socioeconomic status are split, that a lot of those families happen to be white that are leaving. So it's leaving more students of color in the schools. And so it gets pretty hard to desegregate when white families are choosing to go to private school or go to homeschool. What are you going to do? Like force them to go into these schools? I I don't, the lines start to get really blurry when we empower government to be able to, balance things out. Because again, they're the ones who were enforcing the discrimination for so long, and now the we're saying that they're in charge of undoing it. Moreover, underrepresented minority students are more likely to live in poverty and attend schools with high concentration of poverty. And so, again, this happens also because of you're districted to your neighborhood school rather than having some school choice where you can choose to maybe get to a school that's out of your neighborhood or create competition where maybe your neighborhood school is actually better. Um, when combined with residential segregation and school funding systems that rely heavily on local property taxes, this leads to racial minority students attending schools with fewer resources. In turn, underrepresented minorities are more likely to attend schools with less qualified teachers, less challenging curricula, lower standard test scores, and fewer extracurricular activities and advanced placement courses. It is thus unsurprising that there are achievement gaps along racial lines, even after controlling for income differences. Systemic inequalities disadvantaging underrepresented racial minorities exist beyond school resources. Students of color, particularly Black students, are disproportionately disciplined or suspended, interrupting their academic progress and increasing their risk of involvement with the criminal justice system. Underrepresented minorities are less likely to have parents with post-secondary education who may be familiar with college application process. Further, low-income children of color are less likely to attend preschool or other early childhood education programs that increase educational attainment. All of these interlocked factors place underrepresented minorities multiple steps behind the starting line in a race for college admissions. In North Carolina, the home of UNC, racial inequality is deeply entrenched in the K 12 system. State courts have consistently found that the state does not provide underrepresented racial minorities equal access to educational opportunities, and that racial disparities in public schooling have increased in recent years in violation of the state constitution. These opportunity gaps result in fewer students from underrepresented Black backgrounds even applying to college, particularly elite universities. Brief for Massachusetts Institute of Technology. Because talented lives everywhere, but opportunity does not, there are undoubtedly talented students with great academic potential who have simply not had the opportunity to attain the traditional indica of merit that provided a competitive edge in the admissions process. Brief for Harvard student and alumni organizations. Okay, so that's where they got that from. Consistent with this reality, Latino and Black students are less likely to enroll in institutions of higher education than their white peers. Given the central role that education plays in breaking the cycle of racial inequality, these structural barriers reinforce other forms of inequality in communities of color. All right, so she gives a bunch of quotes. Okay, put simply, society remains inherently unequal. And this is a quote from the Brown case. Racial inequality runs deep to this very day. That is particularly true in education, the most vital civic institution for the preservation of a democratic system of government. Ooh, we are in trouble. So our education system is having issues. As I have explained before, with the eyes open to this reality, only with eyes open to this reality can the court carry out the guaranteed protection or the guarantee of equal protection. Both UNC and Harvard have sordid legacies of racial exclusion because context matters when reviewing race conscious college admissions. Grutter. All right, how many more pages do we have, Sotomayor? Pretty sure she goes on for quite some time. I don't know if I have it in me to read this all out loud to you guys. Let's skip down here to this next truth. So she goes through just some more stuff about racial inequality and the state of our country. And I think that a lot of these facts, again, like we can agree with them. Like how we're putting them together in the story we're telling, perhaps that might be slightly different, but point we understand, point well taken for sure. I don't think any of us take any of this lightly, or any of us want to whitewash this history, or any of us want to ignore this history. Um, so she says these may be uncomfortable truths, but to some, but they are truths nonetheless. Institutions can and do change. However, as societal and legal changes force them to live up to their highest ideals, right? So she's saying you have to be forced to change. They're not going to be forced to change unless we have these policies. It is against this historical backdrop that Harvard and UNC have reckoned with their past and its lingering effects. Acknowledging the reality that race has always mattered and continues to matter, these universities have established institutional goal of diversity and inclusion. Consistent with the equal protection principles in this court settled law, their policies use race in a limited way and with a goal of recruiting, admitting, and enrolling underrepresented racial minorities to pursue the well-documented benefits of racial integration in education. Today, the court stands in the way of a respondent's commendable undertaking and entrenches racial inequality in higher education. The majority opinion does so by turning a blind eye to these truths and overruling decades of precedent content for now to disguise its ruling as an application of established law and move on. As Justice Thomas puts it, Grutter is, for all intents and purposes, overruled. It is a disturbing feature of today's decision that the court does not even attempt to make the extraordinary showing required by stare decisis. The court simply moves the goalpost, upsetting settled expectations and throwing admissions program nationwide into turmoil. In the end, however, it is clear why the court is forced to change the rules of the game to reach its desired outcome. Under a faithful application of the court's settled legal framework, Harvard and UNC's admissions program are constitutional and comply with Title VI of the Civil Rights Act of 1964. So in the end, however, it's clear why the court is forced to change the rules of the game to reach its desired outcome. Under a faithful application, okay. Answering, I wonder what that is. I wonder, she says it's clear. In the end, however, it's clear why the court is forced to change the rules of the game. I wonder why. What is that? It's not clear to me. Answering the question whether Harvard and UNC's policies survive strict scrutiny under settled law is straightforward, both because of the procedural posture of these cases and because of the narrow scope of the issues presented by the petitioner students for fair admissions. These cases arrived in the court after 2 lengthy trials. Harvard and UNC reintroduced dozens of fact witnesses, expert testimony, and documentary evidence in support of their admissions program. Brief for petitioners 2040 SFFA, by contrast, did not introduce a single fact witness and relied on the testimony of 2 experts. After making detailed findings of fact and conclusion of the law, the district courts entered judgment in favor of Harvard and UNC. The First Circuit affirmed the Harvard case, finding no error in the district court's thorough opinion. SFFA then filed petition for writ of certiorari in both cases, which the court granted. The court granted certiorari on 3 questions. 1, whether the court should overrule Backrutter and Fisher, or alternatively, whether UNC admissions program is narrowly tailored and whether Harvard's admissions program is narrowly tailored. Answering the last 2 questions, which call for application of settled law to the facts of these cases, is simple. Deferring to the lower court's careful finding of facts and credibility determinations, Harvard and UNC's policies are narrowly tailored. As to narrowly tailoring, the only issue SFFA raises in the UNC case is that university cannot use race in its admissions process because race-neutral alternatives would promote UNC's diversity objectives. That is so easily resolved in favor of UNC that SFFA devoted only 3 pages to it in the end of its 87-page brief. The use of race is narrowly tailored unless workable and available race-neutral approaches exist, meaning race-neutral alternatives promote the institutional's diversity goals and do so at tolerable administrative expense. Narrow tailoring does not mean perfect tailoring. The court's precedent made clear that narrow tailoring does not require exhaustion of every conceivable race-neutral alternative, nor does it require a university to choose between maintaining a reputation for excellence or fulfilling a commitment to provide educational opportunities to members of all racial groups. As the district court found, after considering extensive expert testimony, SFFA's proposed race-neutral alternatives did not meet those criteria. All of SFFA's proposals are methodically flawed because they rest on terribly unrealistic assumptions about applicant pools. For example, as to one set of proposals, SFFA's expert unrealistically assumed that all the top students in the candidate pools he used would be admitted and enrolled. In addition, some of SFFA's proposals force UNC to abandon its holistic approach to college admissions, a result in deep tension with the goal of educational diversity as this courts have defined it. Others are largely impractical, not to mention unprecedented in higher education. SFFA's proposed top percentage plans, for example, are based on made-up and complicated admission index that requires UNC to access real-time data for all high school students. UNC is then supposed to use that index, which would change every time a student took a standardized test to rank students on all grades and test scores. SFFA's top percentage plans would even nearly erase the Native Americans incoming class at UNC. The courts below correctly concluded that UNC is not required to adopt SFFA's unrealistic proposals that satisfy strict scrutiny. All right, so that's an interesting part of the case that I guess, yeah. So it goes on. Kind of running out of steam here. I do think that it would be important to go through and read each of these points and really fully try to understand the argument that she's making, because she does seem to confront directly some of the arguments made in the court's decision, as well as some things that we wouldn't know from just reading the decision, but we might have had to read the briefs to get all of the details about. I do think that nonetheless, though, you can get a pretty good sense of the arguments from each side. I think it's very interesting how much time that Sotomayor really took to build up that history and tell that whole story, and making references to all sorts of books rather than legal cases. Um, I think some of the things that she was saying were relevant, and it does really bring to light the history of how we have struggled and grappled with this as a nation. And I would like to see the conversation more around, well, how should we handle these things? Was the civil rights legislation the right way to do it? Was the 14th Amendment the right way to do it? Were some of these other laws the right way to do it? We should have a robust, constitutionally based argument on these ideas, and really start asking ourselves that, do we need more laws to say that the original founding values and principles should stand? Like, do we need more laws to tell us that we are all equal because we've all been given our rights from God, right? Like, that the self-evident fact. Do we need more laws to be like, hey, you should do that thing, and here's all the details about why you should do it, which then become complicating because they're so context specific, whereas, they're just about race here, but we know that, what about religion, right? What about parents, right? Parental rights is this whole thing. So we get all these different sorts of rights groups, and everybody wants their own legislation to be like, oh, I have rights here and I have rights here and I have rights here. Well, really, we're all individuals. We don't need necessarily these special categories. And one of my and Sotomayor really starts to get into this is this idea of color blindness versus having laws that say, well, everybody should be treated like a white person, right? Like, so it's not easy. And both sides make it seem like it is so simple. I tend to agree in this circumstance with one side more than the other, but I don't think just because I agree with the way that the decision turned out doesn't mean that I agree with it for the same reasons or have the same interests or agenda to push because of that. And I'm much more interested in the conversation that we can have. I'm much more interested in reviving a robust constitutional culture that I think has existed throughout various periods of time of American history and has waned in others. And as calamitous as these times might be, and I don't see them necessarily becoming any less so, particularly in the next, year or so until the 2024 election. I am optimistic about the future. I am optimistic that, we're going to come to our senses. We're going to make it through this and we are going to be stronger and we are going to continue this beautiful experiment that we have in this country that I am so grateful to be a part of with all aspects of it, the good, the bad, and the ugly, which is actually the name of the curriculum that I am working on for a high school history course. So I'm going to be talking more about that and I would love to have a broader conversation just about some of the ideas in here. It doesn't have to necessarily be tied to this specific SCOTUS case, but we touched on a lot of great things, great things, or we touched on a lot of important ideas to unpack, and that I would love to do whole separate podcasts, videos on in and of themselves. But I'm definitely going to be trying to go live more. I'm just doing so much work right now in terms of things that pay the bills and doing this isn't necessarily doing that. I would love to create more highly produced videos, but for now it's going to have to be going live, going through my thought processes out loud with you. Hopefully you find that model good, but definitely hit that like button if you haven't, help this video get more views. Subscribe if you're new here so you don't miss any of my videos. I go live um, definitely on Saturday nights, though. This holiday weekend, I'm not going to be here, but basically every Saturday night I go live. And now throughout the week, I'm trying to get in more live shows too. So check back. Let me know what you think about this in the comments down below. Do you agree with the decision? Do you disagree with the decision? What do you think about the reaction from social media and the media and people who you're talking to in real life? And what other topics do you think that we should cover? Maybe it's another Supreme Court case. So till next time, keep that face beautiful and keep thinking free. So, when we think free, we live